Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about how to sell or refi your real estate that you have put into your trust. Before I get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay. So I'm sure I've talked about this before, but I thought I would get back on the bandwagon with a nice, simple, easy question. Took last week off for Thanksgiving, and I'm ready to get back in the saddle. But I wanted to take a minute I wanted to answer an easy question, basically. I wanted to answer something that doesn't take too much time, too much thought, so that you can also get back into the groove of listening to this amazing estate planning information. So, actually, this is a question I think I got asked twice today. Did a few will signings today. Mondays are the day for will signings, and I thought I would talk about it because, like I said, it is a frequently asked question. It is a good question, and the answer is relatively straightforward. So, what happens is you create a revocable living trust, and when that happens, you put your real estate into said trust. This is both a probate avoidance tool. And also, the trust gives you long-term oversight and management over your assets. But while you are alive, it is likely that you are going to want to refinance the mortgage on that house or sell the house. And when that happens, how does your trust come into play? The answer is really, it depends. But the outcomes are not that different and are not that difficult. They're not that problematic. They don't cause any concern. So the first thing that can happen is if you sell your house, most of the time these days, the banks will just allow you to sell the house in the name of your trust, which the only difference is when you signed your original note and your original deed. I guess you didn't sign the deed. When you signed your original note, you just signed it as yourself. Now when you sign it as, when you sell your property, when you sign the deed, you will just sign it as trustee of your trust. Sometimes financial institutions, banks, will want you to move the property out of your trust back into your name to execute the deal, and then you can move the property back or whatever you buy into your trust when you're done. This sort of keeps the title clean. I think it's kind of overkill, but banks, they like to overkill. So that's one possible solution. The other thing that can happen is when you are trying to refi your house, it's kind of a similar situation. Oftentimes, the bank will let you refinance your home that is in your trust by keeping it in the trust. Only thing that happens is you sign a new sort of mortgage. It's not exactly a mortgage. You sign a new note, but the note is in your personal name, and then the property is still owned by your trust. I think most banks are okay with the fact that when you have your property in your revocable trust, it's basically your property still. There's no real difference between the two. And I think banks are starting to just acknowledge that and be a little less worried about that circumstance. The other thing that they can do, which they often will do, I guess, is to have you move your property out of your trust, complete the refi, and then move your property back into your trust when you are done. Either way, that's probably like a $400 problem here in Washington State, and that's only because the recording fees to record the deed as you move the property in and out are like $200 a piece, $220. So that's the answer. That's the solution, and hopefully that made sense. Hopefully, if you have a trust, you're less worried than you were before. There's really no need to worry. Every problem is fixable, and that's it. So, as always, if you like this, please hit the like button. If you have a question or comment, leave it. I will answer it. If you know someone that needs to hear this, please share it with them. And if you have any questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, that is it for today. As always, I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.